Morning, and thank you for coming to this lecture on property issues in insolvency. My name is Orla Courtney. I work in the real estate department of McCann Fitzgerald Solicitors, and more specifically in the area of real estate finance. For a considerable period during and after the recession, a good proportion of the work in which real estate lawyers were involved consisted of transactions to which a receiver or other insolvency practitioner was a party. The purpose of this lecture today is to look at the issues which arise in such transactions when acting for or against a receiver or other insolvency practitioner in a conveyancing transaction. Insolvency practitioner is an umbrella term which can be used to refer to any professional acting in an insolvency procedure. There are 6 examples listed here: a receiver, liquidator, examiner, rescue process advisor, official assignee, and a receiver manager. Today, we're going to focus on receivers, including statutory receivers, liquidators, and examiners. Annual insolvency statistics indicate that the trajectory of insolvencies in Ireland is generally upwards since 2021, and this continues in 2024. It merits attention as when we're dealing with an insolvency practitioner, the transaction differs in certain respects from your standard conveyancing transaction. We're going to start by considering the role of each insolvency practitioner to look at their appointment and the specific property issues that arise. We'll then discuss their powers, i.e. what contractual or statutory powers they have. We will then look at some specific property issues, including drafting a contract for sale when acting for an insolvency practitioner. We'll consider Law Society Conveyancing Committee guidelines and recent case law. We'll look at liquidators and specifically focus on a liquidator's ability to disclaim leases. We'll look at examiners and, again, ability to repudiate contract and leases. We'll briefly consider NAM's powers in relation to the appointment of receivers, and also mention SCARP, which is the Small Companies Administrative Rescue Process. To start with, I want to look at the types and functions of a receiver, as they are by far the most common insolvency practitioner that we encounter in practice. A receiver is appointed over assets or a certain class of assets, and his or her function is to receive the secured assets and take control and sell them and pay the proceeds to the bank in satisfaction or partial satisfaction of the outstanding debt. There are different types of receiver, and we will touch on these and their different powers and limitations throughout the lecture, but for now I've listed examples of the different types on this slide. First one we see is the contractual receiver. A receiver is generally appointed on foot of the provisions contained in a security document, i.e. your debenture, your charge, your mortgage, that was entered into between a borrower and a bank. This is referred to as a contractual receiver. So we see that the basis of the entitlement to appoint the receiver and the receiver's powers are derived from the security contract. So we check the security document to see that it provides the lender with the power to appoint a receiver. And we'll look at this in more detail later on in the lecture. Second type of receiver listed on the slide is the Conveyancing Act receiver. If there are no powers in the mortgage documents, we look to legislation to determine the appointment requirements. And the critical date here is the 1st of December 2009. The provisions of the Conveyancing and Law of Property Act 1881 apply to mortgages created prior to the 1st of December 2009, and those of the Land Conveyancing and Law Reform Act 2009 to mortgages created after that date. And again, we will look at these in more detail later on in the lecture. The third type of receiver mentioned on the slide is your statutory receiver, and this would be a receiver who is appointed by NAMA pursuant to Section 147 of the NAMA Act 2009. And lastly, the High Court has jurisdiction to appoint receivers on application. It's important to remember that receivership can affect both corporate entities and individuals, and today we focus on a receiver appointed to a company, and specifically the impact in the conveyancing transaction of a receiver appointed to real property owned by a company under a security document, as opposed to a receiver appointed to the company itself. A receiver is appointed over assets or a certain class of assets, so the status of the company doesn't change on the appointment of a receiver. The board of directors remains in situ. If there are other assets in the company not affected by the receivership, the board can continue using and trading them, and both the board and the receiver can operate in tandem. However, the powers of the company and the director's authority are suspended in relation to the asset that's covered by the receivership and can only be exercised with consent of the receiver. Equally, receivers and liquidators can coexist. If there's no aspect of the business remaining after receivership, a liquidator must be appointed, however, to bring about dissolution of the company. Examination can impact on the ability to appoint a receiver. If a company is in examinership, it enjoys court protection, so a receivership cannot be instigated. If a receiver is appointed to a company, the company has 3 days then to apply for court protection, and if examinership is granted, the receiver is then stood down, not discharged, mind you. Where an application for examination is then successful, the scheme of arrangement is binding on the creditors, and therefore the receiver cannot act. But if the application for examinership is unsuccessful, the receiver's appointment is and can then be reactivated. You should also note then that if a receiver is appointed for a period in excess of 3 days, an examiner cannot be appointed. Turning to the validity of the appointment, we have 3 questions. First is, on what basis is a receiver being appointed? Secondly, when can you appoint a receiver? And thirdly, how do you appoint? So turning to the first question, on what basis is a receiver appointed? We look to see, is it contractual or statutory? The first step is to check the relevant security document to see if it provides for the appointment of a receiver. If it doesn't, or if it doesn't afford the secured creditor adequate powers, the secured creditor may seek to appoint a receiver under statutory powers, and this is what we refer to as a Conveyancing Act receiver. So the receiver is appointed under either the 1881 Conveyancing and Law of Property Act in respect of security which was entered into before the 1st of December 2009, or if the security document postdates the 1st of December 2009, we look at the Land Conveyancing and Law Reform Act 2009. There is provision for the appointment of statutory receivers under the NAMA Act 2009, which we will deal with separately later. Second question we look at then is, when can you appoint? For a contractual receiver, we must check the terms of the security document to see when the lender is entitled to appoint. Generally, this would be where there's an event of default which is defined in the security document. Typically, this would be default in payment by the borrower, insolvency of the borrower, or failure to comply with specific covenants. For a statutory receiver, the entitlement to appoint is dealt with in the relevant NAMA legislation. For Conveyancing Act receivers appointed under the 1881 Act, this is when the secured debt has become due. For a Conveyancing Act receiver appointed under the 2009 Act, we turn to Section 108 of the 2009 Act, and we see that the secured creditor can appoint a receiver in any one of the following 3 circumstances. 1, where the charger has been asked to pay the secured debt and has failed to pay all or part of that debt for 3 months. 2, where interest is unpaid for 2 months after becoming due. Or 3, where the charger has breached a provision of the security other than the covenant to pay. In respect of contractual receivers, usually, except in the case of housing loan mortgages, which are subject to a more restrictive regime, the security document will expressly provide for a receiver to be appointed without the restrictions or conditions to that appointment set out in either of the 2009 Act or the 1881 Act, and further supplementing the powers of the receiver by delegation of the secured creditor's own powers, so that the receiver's powers are as broad as possibly required to facilitate the recovery of the debt, including a power of sale. I mentioned housing loan mortgages here, and the funders cannot contract out of the application of the 2009 Act in respect of these mortgages regarding possession and exercise of power of sale, and we'll touch on this in more detail later on. Third question is, how do you appoint a receiver? So receiver is typically appointed following the service of a notice or a demand on the mortgage or chargeor requiring repayment of the sum advanced within a specified period of time. Typically this is very short, within 24 hours. The lender appoints the receiver by way of a deed of appointment, and it's the deed of appointment that has generated much case law in recent times. So you should review the deed of appointment to check that it correctly references the right security document, the correct parties, the property description, and that it's correctly executed. You're seeking to ensure that there are no discrepancies on the document. And two recent High Court cases are mentioned on the slide, in both of which the appointments of receiver were challenged on the basis that the deeds of appointment were invalidly executed. In the first case of McCleary and Phillips, this involved a receiver purportedly appointed by ACC on foot of provisions in ACC security document. In this case, while the relevant mortgage provided that the appointment of the receiver should be made by signature, the deed of appointment was executed by the affixing of the company seal, and it hadn't been signed by any of the three individuals authorised to execute documents on behalf of the bank. The court found that the appointment of the receiver was found was invalid and that the borrower was entitled to damages for trespass. In the second case, Ken Fennell and Gilroy and others, this involved an AIB mortgage, on foot of which a receiver had been appointed. The mortgage incorporated the AIB standard mortgage conditions, and the relevant provisions of the security document, as with the ACC case, provided for the appointment of the receiver by writing underhand. AIB executed the deed of appointment by affixing its company seal, and then the affixing was witnessed by two employees who were authorised signatories, who were entitled to subscribe their names as part of the sealing process. For prudence, following the McCleary and Phillips case, AIB's board passed a written resolution expressly ratifying the signature of the persons who witnessed the affixing of the seal, and the court distinguished McCleary on the facts. And it found that the signatories were authorised to sign on behalf of the bank, and affixing the seal didn't change that. And it relies on the principle of agency, that the principal can ratify the authority of the agent retrospectively. I mentioned another case of Harrington and Goland Property Finance Limited. We will mention this later in relation to the registration of lender charges in the case of registered land. However, in that case, as a result of the finding in that case, it's recommended that a transferee of registered charges registers the instrument to transfer in the land registry prior to the appointment of the receiver over charged lands. In Harrington, the plaintiff applied for an injunction seeking to halt the appointment of a receiver. Goland had acquired the loan under which it sought to appoint a receiver from another lender, and the appointment was challenged on the basis that the relevant Form 56 affecting the loan transfer to Goland in the land registry was not registered in the land registry, and on that basis, Goland had no authority to appoint the receiver. The court held that Section 64.2 of the Registration of Title Act should be interpreted to mean that until a Form 56 to affect the transfer of the security is registered in the land registry, the transferee of a charge has no interest in the charge, and no contractual rights arising under that charge are conferred on the transferee, and therefore it was arguable that a lending institution could not appoint a receiver until the registration completed in the land registry. The decision was made in the context of an interlocutory injunction application, making it of persuasive authority. In the later case then, however, of Woods and Ulster Bank, Ireland, it was found that the contractual power to appoint a receiver was not dependent on the registration of the lender as owner of the charge in respect of the registered land. So we see that while it's not necessary for a receiver appointment that the transfer of a charge be registered in the land registry, separately for the purposes of exercising power of sale over registered land, which we will look at shortly, it is crucial that in order to rely on the statutory powers afforded by the Registration of Title Act, that the mortgagee is registered as owner of the charge. The McKenna case mentioned on the slide concerns a successful appeal to the Court of Appeal against the refusal in the High Court to award an injunction in the case of a sale of property by a receiver. In that case, the security initially in favour of Irish Nationwide Building Society, then Anglo-Irish Bank Corporation, and was subsequently transferred onto a lender called Shoreline. That lender appointed a receiver due to borrower default on the loan, and the loan and the security was subsequently sold to Pepper. You should note at this point that the novation of the receiver was not executed. The novation of the appointment of the receiver was not executed at the time of the loan sale to Pepper, but some weeks after that. The receiver then contracted to sell the secured property after the loan sale. The borrower challenged the sale by the receiver and asserted that because there was an absence of a valid deed of novation, the sale by the receiver was a slander of its title. And the court found in this case that there was a valid case to answer on this point, the issue being that the deed of novation neither predated nor was it contemporaneous with the loan sale and transfer. This decision is provided in the context of an appeal against a refusal to grant an injunction, and we await the outcome of the determination of this matter at plenary hearing. Once you've confirmed that the receiver is validly appointed, you should then check what express powers are provided in the security document. So we look to see whether the security document provides for power to appoint the receiver, a receiver power of sale, and bank power of sale. The security document will usually authorise and empower a receiver to, amongst other things, take possession or otherwise assume control of the property charged by the security document, to sell that property, to carry on the business of the company, and to compromise claims. Section 19.1 of the Conveyancing and Law of Property Act 1881 conferred a power of sale on all mortgagees, and provided the mortgage was made by deed after 1881, and the 2009 Act maintains this principle. While a secured creditor can also appoint a receiver under both acts, there is no express power of sale in the Act for receivers. Where a receiver is appointed under either the 1881 Act or the 2009 Act, the receiver's appointment will only be over the income generated from the property, and there will be no receiver power of sale. This was the case until the 2014 Companies Act. Helpful changes in relation to receiver of the property of a company were introduced by Section 437 of the Companies Act, which provides various powers to such receivers, including the power to lease, let on hire, or dispose of property of the company, and therefore it includes the power of sale. However, for a receiver to use these powers, the security document must contain a contractual power to appoint a receiver, and this provision is retrospective. Housing loan mortgages are mortgages to secure a housing loan, which is a loan to purchase, provide, improve, or refinance a house to be used or to continue to be used as a principal residence of the borrower or its dependents. Looking at the case of Bank of Ireland Mortgage Bank and Niall and Joyce Haid, this is a recent case where mortgages were provided variously by the Haids in respect of a residential investment property portfolio. The Haids fell into arrears on their loans, and the bank demanded on the loans and appointed a receiver who proceeded to take possession of the properties and dispose of them. Separate proceedings were issued by both parties, and in the quoted proceedings, the validity of the receiver appointment was, amongst other things, challenged. Mr. Justice Barr found that while the Haids had not acted as consumers in relation to certain 2006 and 2007 loans with the bank, and also that their loans did not come within the statutory definition of housing loans, nevertheless, because of certain wording included in the mortgage documents, which were headed housing loan mortgage, and it provided that the mortgage would incorporate the Irish Banking Federation's general housing loan mortgage conditions in full, the court found there was an agreement between the bank and the Haids that the loan and the mortgages entered into by the parties would be treated as housing loans, and therefore housing loan mortgages, even though they did not strictly come within the qualifying criteria set out in the 2009 Act. Therefore, notwithstanding the mortgage terms, the receiver was required to comply with Section 97 and 100 of the 2009 Act in order to obtain court orders for possession and sale of the mortgage property, and in not doing so had therefore acted unlawfully in taking possession of the properties without the court orders, and exemplary damages in the amount of €550,000 were awarded to the Haids. This was overturned on appeal by the Court of Appeal, which found that Mr. Justice Barr had erred in his interpretation of the mortgages, and that although the general conditions incorporated into the mortgages were subject to the 2009 Act, this crucially did not mean that the bank had agreed to treat the loans as housing loans and the mortgages as housing loan mortgages. Furthermore, Ms. Justice Costello, who delivered the judgment in the Court of Appeal, held that Section 97 of the 2009 Act does not refer to a receiver, and that the receiver in this case had acted lawfully in taking possession of the properties and was not a trespasser, and the Court of Appeal therefore allowed the appeal of the receiver in the challenge to the award of exemplary damages against him, and also the determination that the receiver had acted unlawfully in possessing the properties without a court order. The decision of the High Court had suggested some uncertainty in the settled legal requirements for receiver sales of non-housing loan mortgages, as the Land Registry paused registration of applications for registration of title from receivers pending the outcome of an appeal. In response to this, the Law Society's Conveyancing Committee issued a practice note in May 2023 on the decision, urging that until an appeal is determined, the Conveyancing Committee recommends that practitioners acting in the sale of a property by receiver should consider carefully before entering into a contract whether Section 97 and 100 of the 2009 Act have application, and whether necessary court orders should be obtained. The Land Registry has still not published any update to its practice since the judgment of the Court of Appeal. I'll also mention here a Conveyancing Committee practice note of the 5th of October 2018 dealing with the requirements of the Land Registry where a mortgagee is selling by its power of sale to verify that the relevant security is not a housing loan. In the case of sales by the registered owner of a charge, a court order or borrower consent under Section 100 of the 2009 Act is required to be produced unless that section has been properly disapplied in the relevant charge. The Land Registry notes that this is permitted where the charge is not a housing loan mortgage as defined by the 2009 Act, which in turn requires an analysis of whether the charge secures a housing loan. The Land Registry practice suggests that in applying for the registration of transfer from a charge holder where the registered owner is not a body corporate, the applicant should lodge evidence of the court order or consent required under Section 100, or evidence that the charge is not a housing loan mortgage, the latter by way of a solicitor's certificate being provided to the effect that the charge is not a housing loan mortgage and that the registered owner did not act as a consumer within the meaning of the Consumer Credit legislation at the relevant time. The Conveyancing Committee recommends strongly that practitioners should not provide such a certificate, and it should only be provided by a person authorised to do so on behalf of the charge holder or by way of a certificate contained in the relevant deed of assurance. Whether a borrower acted as a consumer or whether the underlying loan was a housing loan mortgage is likely to be beyond the knowledge of a solicitor representing the vendor or charge holder, and certainly will be beyond the knowledge of a solicitor acting for the purchaser. I now want to talk about the Power of Sale and the Registration of Title Act. Section 62.2 of the 1964 Act provides that until the owner of a charge is registered as such, the instrument shall not confer on the owner of the charge any interest in land. And secondly, Section 62.6 of the 1964 Act provides that on registration of the owner of a charge on land for the repayment of any principal sum of money with or without interest, the instrument of charge shall operate as a mortgage by deed within the meaning of the Conveyancing Acts, and the registered owner of a charge shall, for the purpose of enforcing his charge, have all the rights and powers of a mortgagee under a mortgage by deed, including the power to sell the estate or interest which is subject to the charge. What this in effect means is that in the case of registered land, for a lender to enforce their security and to dispose of property on foot of the charge must be registered on the folio. Until the owner of the charge is registered as such, the instrument shall not confer on the owner of the charge any interest in the land. Turning to Section 90, this section deals with the powers of persons entitled to be registered as owner of land or charges, including the right to transfer or charge the interest in the lands, and it addresses what would otherwise be a gap in the registration process that might arise between the sale of an interest in a registered charge and the registration of an interest in a registered charge. This came to be considered by the Court of Appeal decision of Tanninger, Dack and Kane. This case involved a technical challenge to mortgage enforcement proceedings. The defendant sought to resist repossession proceedings by claiming that the Property Registration Authority, as it then was known, should not have registered a charge in the name of the plaintiff as it had no powers to do so under the 1964 Act. The original mortgage was entered into with the defendant by Bank of Scotland Ireland Limited, whose assets transferred to Bank of Scotland plc by operation of a European directive. While Bank of Scotland Ireland Limited had registered its ownership of the charge in the Land Registry, Bank of Scotland plc had not been subsequently registered as owner of that charge before it transferred the security to Tanninger. The charge remained in the name of Bank of Scotland Ireland Limited until ownership was transferred directly to Tanninger on foot of the sale. The defendant challenged Tanninger's entitlement to rely on its registered charge as Bank of Scotland plc had not been the intermediate registered owner, and therefore Bank of Scotland plc had no power to transfer its right to become the registered charge holder. The defendant also alleged that the Land Registry had been wrong at law to register Tanninger's title. The Court of Appeal noted that Tanninger had been entitled to be registered as owner of the charge based on the provisions of Section 90 of the Registration of Title Act. The entitlement to be registered as owner of the charge had passed to Bank of Scotland plc by defeasance as provided for in Section 60 and 90 of the Registration of Title Act. Further, the Court of Appeal found that the defendant was not entitled to challenge the registration and pointed to the conclusiveness of the register as provided by Section 31 of the Registration of Title Act. The Court of Appeal also noted that the mechanisms were available in limited cases to challenge the content of the register, and such mechanisms were not available in summary proceedings such as these. For the purposes of exercising the power of sale over registered land, as we've already mentioned, it is crucial that for the purposes of relying on the statutory powers afforded by the Act, that the mortgagee is registered as owner of the charge, while noting that the contractual power to appoint a receiver is not dependent on the registration of the lender as owner of the charge in respect of registered land. It's also worth noting that the same issues do not arise with respect to unregistered land. A few final points before looking at more practical issues which arise in a conveyancing transaction. The receiver has a duty of care to the company, but this is qualified by being subordinated to the protection of secured creditors' interests. Section 103 of the 2009 Act provides that the receiver is obliged to ensure, insofar as is reasonably practicable, that it sells the property at the best reasonably obtainable price. The mortgagee, once the property is sold and the first ranking mortgagee's original debt is discharged, holds any surplus funds as trustee for all persons holding any subsequent interest in the property, including subsequent mortgagees. The obligation to take all reasonable care may impact on the contract for sale. So when we're drafting a contract for sale where the vendor is in receivership, it does require a different approach to certain matters than in a normal sale, and it usually requires a more conservative approach being adopted. However, drafting an overly onerous contract could be considered to be negligent. Looking at receiver liability, Section 4384 of the Companies Act 2014 provides that a receiver will incur personal liability unless it's expressly excluded. If the personal liability of the receiver is excluded in the sale contract, which when acting for a receiver vendor you should ensure is the case, claimants in respect of obligations entered into by a receiver, a claimant's only recourse is to the property charged for payment in priority to the rights of the secured creditor. Mention here also receiver undertakings. These are an exception and should not contain limitation of liability language. If this ever arose, careful consideration should be given. As solicitors, we should never give an undertaking unless the fulfilment of the commitment is entirely in our control, and the receiver should also take this approach. In certain limited circumstances where a secured lender has ring-fenced funds or indemnified the receiver, such an undertaking may be appropriate. Any such undertakings should be clear as to the terms and duration, as the receiver will be personally liable at foot of such undertakings. And where such undertaking is provided, the receiver usually will have an indemnity for liability out of the secured assets. Typically, where a contract excludes personal liability, but a receiver undertaking is being provided, such as in the case of local property tax, rates or other payments under contract, there should be no limitation of liability language in such undertaking. The receiver is personally liable on such undertaking. The Conveyancing Committee has issued a detailed practice note on issues arising in receiver contracts, and it is worth reviewing. This practice note is dated the 1st of February 2019. Realisations and remunerations. What can a receiver do with the proceeds of sale? This is set out in statute. Firstly, the fees, costs and charges of an examiner, if any, have absolute priority in receivership. Then, in respect of fixed charges, Section 109 of the 2009 Act sets out the order of priority in which proceeds must be applied. So firstly, all rents, taxes, rates and outgoings whatsoever affecting the mortgage property must be discharged. Secondly, in keeping down all annual sums or other payments and interest on all principal sums having priority to the mortgage in right whereof is a receiver. Thirdly, receiver's fees and any insurances properly payable under the mortgage deed. Fourthly, interest accruing due in respect of any principal money due under the mortgage. And then the sums owing to the fixed charge holder. The position differs with respect to a floating charge. Section 440 of the Companies Act 2014 provides that before a receiver can apply the proceeds realised in discharge of the debts owing to the floating charge holder, he is obliged first to pay the company's preferential creditors. This would be the fees, costs and charges of an examiner. Secondly, Section 10 expenses, which would be expenses, for example, certified by an examiner. Thirdly, payment of the super preferential creditors, i.e. revenue commissioners. This would include any amount actually deducted from an employee's pay by an employer and not paid over to the revenue. Fourthly, preferential creditors as defined by statute. These would include all claims of revenue which don't meet the above criteria to rank as super preferential creditors. It would include employee claims such as arrears of wages, accrued holiday remuneration, claims for statutory minimum notice and unpaid rates for the 12-month period prior to winding up or appointment of receiver. Then receiver's remuneration and expenses, which would usually be provided for in the charge, and then discharge of the sums owing to the floating charge holder. Any surplus funds remaining then are for distribution to a subsequently appointed receiver or liquidator if appointed to the company itself. On remuneration, the receiver is entitled to keep commission out of any money received by him as remuneration and in satisfaction of all costs, charges and expenses incurred by him as receiver at the rate specified in his deed of appointment, provided that this rate does not exceed 5% of the gross amount of all monies received. If no commission specifies, then the rate is to be 5% or such higher rate as the court thinks fit to allow on an application made by receiver. I mention here also some recent changes introduced by the Companies Corporate Governance Enforcement and Regulatory Provisions Act 2024, as a result of which details of receiver fees will now have to be made available to members and creditors, and additional obligations are imposed on receivers to provide information to the registrar, and time limits for provision of such information and returns are shortened in several instances. Previous provisions dealing with the remuneration of receivers will now be aligned to those applying to liquidators. Now I want to turn to some practical issues to be aware of in conveyancing transactions and preparing for sale. The first thing that needs to be done is that you make arrangements to obtain the deeds to the property and the security documentation and check that the power of sale has arisen. We'd look at stamp duty. You review the security document. Remember that charges created before the 7th of December 2006 remained liable to stamp duty, so you need to check the charge document to make sure that if it predates that date, that it's correctly stamped. Typically, difficulties can arise in identifying the property. So, for example, the title documents, assuming they're available, may or may not readily identify the property, and the description from the deed should be verified as accurately reflecting the physical property on the ground. You need to check, are there any ransom strips where the property being sold doesn't have adequate access to erosion charge or services? Is there a land registry compliant map of the property? Where the company bought the property originally from a connected party, such as the director or shareholder or a group company, you need to ensure that the title boundaries correspond to the property on the ground and that there's access to the property. There'll be various searches then to be carried out, and as we will discuss when looking at drafting contract for sale, often in receivership sales, one of the biggest challenges is lack of information about the history of the property. Therefore, searches should be carried out to help identify the property, as well as to verify is the entire property captured by the security, has the security been registered in either of the registry of deeds and the land registry, as well as the borrower's title to the property. Have any parts been sold since security was taken? Have any deeds of discharge or release been registered in either registry? Are there any other prior charges? In the case of registered land, you need to clarify what dealings, if any, are pending registration against the property if it's registered land. If there are any outstanding queries on dealings, with whom does responsibility to deal with queries lie? What practical steps can be taken by the lender to resolve outstanding queries in order to effect registration? Is it necessary to engage with other lawyers in respect of the dealings pending? You need to check also that the chargeor is still in existence and obtain company constitutional documentation. You should also carry out planning searches, which would include checking the derelict sites register and vacant sites register. There are a number of land taxes that also need to be checked in considering the status of the property. We've already touched in detail on the charge registration point. You recall that we discussed the registration of the security, and if it is not registered, the dealing whereby the application for registration of the charge is pending in the land registry should be inspected to check its status and the steps necessary to progress the dealing to a conclusion. The alternative to disposing of the property in the absence of the registration of charge is obtaining a well-charging order. Or in the case of a company, it could be considering a share sale or a liquidation of the company, the appointment of a liquidator in order to effect a sale. It's also important when acting for a receiver to obtain the VAT history of the property, preferably from the date of the creation of the mortgage. The receiver is liable to account for VAT and also to provide all relevant information to a purchaser. Mentioning intergroup and intercompany transfers, it's important to clarify whether there have been any intergroup transfers within the past 2 to 8 years, as this could involve a possible clawback of tax. For the sale of property outside a company group where CGT or stamp duty reliefs have been claimed on transfers intergroup, there's a potential to trigger a tax clawback. So the potential for such clawback must be investigated by the receiver in the context of the sale of the property. Finally, in the case of commercial property, as a solicitor acting for a receiver, you should check to see whether any new occupational interests have been granted since security was taken, or whether there have been any variations or changes in any existing occupational arrangements. Having looked at some of the practical issues, now I want to look at the issues which arise when drafting the contract for sale. Many of those issues that arise when acting for a receiver vendor derive from lack of information. The receiver may have no personal knowledge of the property and may not have all of the title documents, and in many cases the borrower will not be available to assist or is being uncooperative. Therefore, there's often a play-off between the lack of knowledge of the receiver, the disgruntlement of a borrower, and as against a desire not to impose overly restrictive conditions. There's helpful guidance from the Conveyancing Committee set out in a number of practice notes, in particular practice note 6th of June 2014, which discusses receiver contracts and special conditions. The difficulties for receivers showing ideal title are recognised and acknowledged as largely due to the absence of appropriate documentation, which leaves receivers obliged to offer restrictive title. However, the inclusion of excessively harsh conditions is discouraged. The practice note refers to the rule in Halloran and Friends Provident that requires mortgagees and receivers to obtain the best price for properties, which would in most cases involve offering the best title that's reasonably available. Whether or not a borrower could maintain a successful challenge against a receiver for failure to obtain the best price would depend on a number of factors, including whether the borrower could actually show loss as a result. If the borrower's total indebtedness is in excess of any potential difference, it would be hard for a borrower to show loss. The contract for sale by receiver should be reasonably balanced between the protections provided for the receiver and the rights afforded to a purchaser. The absolute exclusion of contract representations and warranties so that a purchaser gets no protection whatsoever in a contract is not appropriate. Special conditions to exclude receiver personal liability are acceptable, as we mentioned earlier. However, it's not acceptable to seek indemnities from a purchaser, save in exceptional circumstances. Where general condition warranties are required to exclude it, the receiver nonetheless should confirm matters insofar as it is within his or her knowledge or belief. Statutory requirements should be observed by receivers, as with any other vendor in the case of taxes and charges, for example, local property tax. The provisions of declarations, letters of roads and services from local authority or Irish Water is appropriate, and dealing with MUDS Act developments and associated replies to requisitions of title are also considered by the Conveyancing Committee. Examples of restrictive conditions identified are Conditions which are unlawful, such as restricting the right to inquire as to whether stamp duty is paid. This is not an acceptable special condition to include in the contract. Conditions which might be unenforceable because the courts are unlikely to grant decrees of specific forms of the contracts include restricting a purchaser's right to raise requisitions, relieving the vendor or solicitor from the obligation to explain acts on searches, and refusing to disclose known latent defects in title. Conditions that are considered not in accordance with good conveyancing would be 1. Refusing to provide the borrower's tax number to enable the purchaser to stamp a purchase deed, or a condition requiring payment of a deposit to a receiver instead of the receiver's solicitor. In relation to deed of assurance, except in the case of units in a multi-unit development or where very particular circumstances apply, it's inappropriate for a vendor to insist on a particular form of assurance being used or to prescribe that the vendor will settle the form of deed of assurance unilaterally following exchange of contracts. And the Conveyancing Committee reiterates its previous general recommendation that where a vendor or solicitor is varying or excluding a particular general condition, the reason for its exclusion or variation should be disclosed. Further, Conveyancing Committee practice notes of 1 December 2017 details a special condition which sought to provide that a vendor would not be bound by any of the terms and conditions in the contract, and further the exclusion of contract warranties. And the Conveyancing Committee indicated that this type of special condition is completely unacceptable. In a further June 2017 practice note, it gave an example of a no-recourse special condition, which again was indicated to be unacceptable. It is worthwhile and will be useful to consult these various practice notes for a considered discussion of the various types of condition which are unacceptable and are not to be utilised. Coming back to declarations, a Conveyancing Committee practice note of February 2019, the 1st of February 2019, is of assistance in this aspect. Typically, contract special conditions will be drafted to provide for the content of such receiver declarations, which should be made on the basis of the receiver's actual knowledge, information and belief, having made the appropriate inquiries. This would be knowledge and information from documents available or in the receiver's possession and of which he or she is actually aware. Usually, the contract special condition will specify that a template form of declaration, which is provided with the contract, setting out the limited basis of the receiver declarations that will be provided. In drafting the contract for sale and in specifying the vendor, the name should refer to the vendor as the vendor acting by the receiver throughout the contract. So you include the name of the vendor with the words after it, acting by the receiver. Looking at the exclusion of General Condition 32 in relation to development, the Committee in its 6th of June 2014 practice note recommends that a receiver should furnish to a purchaser all evidence and documentation in relation to the planning status of the property that's in their possession, along with copying to the purchaser all notices furnished by any competent authority. In practice, it's helpful, particularly in the case of the sale of a larger or more complex property, and it's also not unusual for the receiver to commission its own planning report on the property and to consider sharing it with the purchaser on a non-reliance basis. This should be done without prejudice to any qualifications provided in the special condition dealing with General Condition 32. So in practice, while the warranties provided in General Condition 32 are excluded, all of the relevant information that the receiver holds, together with the planning report, if available, should be provided. On boundaries, it's possible that a receiver may never have seen the land and sale in person before, and therefore the receiver should not define boundaries, fences, ditches, hedges or walls, or specify what boundaries are of party nature. The receiver may nonetheless have to commission and provide a declaration of identity. And in this case, the purchaser will have to carry out their own diligence while having reliance on the declaration of identity. The receiver should make inquiries as to whether the roads and services are in charge. And a special condition should also be included to address the receiver's lack of knowledge of the property and the title. Turning to notices, the contract general condition should be restricted to notices of which the receiver is actually aware. Contents. Sometimes agents, as a matter of course, include contents in the sale. However, you need to check the terms of the security document to see if it includes contents and if the receiver can actually sell the contents. If the receiver is appointed under a fixed charge, it may not extend to contents, and the contract will have to be amended in order to exclude the inclusion of contents in the sale. Turning to insurance, you should General Condition 43 to the amount of insurance cover actually available, as there may be problems getting insurance if the property is left unoccupied. And just as a general final point, the committee reiterates in its guidance its previous general recommendation that where a vendor or solicitor is varying or excluding a particular general condition, the reason for its exclusion or variation should be disclosed. Turning to judgment mortgages. In the case of judgment mortgages on title, your contract for sale should provide for the ability of the receiver to call on the mortgagee to assure the property to defeat any judgment mortgages or other encumbrances to which the lender has not consented. The mortgagee not in possession shall exercise the power of sale pursuant to the mortgage or charge. The Conveyancing Committee noted in its 2019 practice note that a purchaser shouldn't have difficulty with this. You should note as well that the exercise of the power of sale does not require the mortgagee to be in possession, although consideration has to be given as to how physical possession is to be delivered. The remedy of possession is rarely used by mortgagees because of concerns about the duties of mortgagees in possession and potential liabilities that they might incur, for example, under environmental legislation. It's therefore more common for the receiver to be appointed who will enter into possession of the property. This would be particularly relevant if the receiver is required to oversee the completion of property development. In practice, the only time a mortgagee will exercise the power of sale is to overreach subsequently registered charges to deliver good title to a purchaser, which it will typically do as mortgagee not in possession, following the receiver's appointment and negotiation of the sale. A mortgagee exercising the power of sale has power to convey the property freed from all estates, interests and rights of which it has priority and subject to all such which would have priority to the mortgage. And there's no obligation to discharge subsequent mortgages. However, the receiver has an obligation to act in a manner which is fair and not detrimental to the interests of subsequent mortgagees. We know from the Supreme Court case of Marr and Dublin City Council that this overreaching power extends to charges in relation to unpaid derelict sites levies incurred or post-dating the date of the security documents. Where the power of sale has arisen, the owner of a charge on foot of Section 62.2 of the Registration of Title Act 1964 can sell on foot of the charge free from all adverse entries on the folio to which it has priority. Turning then to Section 1173 of the 2009 Act. This addresses the position of the judgment mortgagee as a volunteer. A purchaser from a first mortgagee acquires an unencumbered title. The judgment mortgage as provided in Section 1173 is subject to any right or encumbrance affecting the judgment debtor's lands, whether registered or not, at the time of its registration. Finally, in relation to receivership, I would like to look at the documents that are required in closing, execution requirements, and some taught errand requirements. The closing documents. In addition to those required in a normal conveyancing sale, a purchaser should be provided with the documents listed on the slide. We see proof of the right to appoint a receiver, a certified copy of the deed of appointment, a certified copy of the mortgage document. The original may well be available in the case of unregistered title, and in the case of registered title, the original will be lodged in the land registry under the relevant instrument. And the original paper deed of release post-dating completion. It's critical that the deed of release does not predate the deed of assurance, as this is the basis upon which the receiver is acting. It's particularly important in a receiver sale not to use an e-discharge, which we'll be touching on later on in the lecture. You should also seek receiver confirmation that the appointment has not been challenged, and this can be provided by letter confirmation. And you'll see mentioned there in the slide, assuring the nominal reversion. As Section 80, subsection 2 of the 1980 Landlord and Tenant Amendment Act 1980 was repealed by the 2009 Act, the practice in the case of unregistered leasehold being purchased from a vendor as a mortgagee in possession is to ensure in the purchase deed that where the mortgage was by a subdemise, that the nominal reversion is, in addition, assured by the attorney appointed in the mortgage document to do so. Now we turn to look at how a receiver correctly executes a deed. The receiver has no authority to affix the company seal. It's worth remembering that the status of the company does not change during your receivership, and the board of directors remains in situ. Accordingly, the receiver does not have authority to fix the company seal. The Supreme Court set out guidance in the case of IDA and Moran for the execution of documents by receiver. In acting for a company, the receiver writes the name of the company, and underneath this, he or she writes words that indicate that the name of the company was written by the receiver as attorney of the company, under power of attorney given by the debenture. The receiver then executes the deed in his or her own name. The receiver executes as attorney for the company. And then it's important for the receiver to separately join in the deed in his or her own personal capacity, as once the receiver is discharged, they will need locus standi to rely on the limited liability language and to enforce the contract if necessary. The company seal cannot be affixed by the receiver, and in the case of an individual, the receiver will execute as attorney of the owner. You should check in the case of joint receivers to see the criteria for execution of the documents. Sometimes the deed of appointment will provide for execution by both, or it may well be either. Closing requirements in relation to Tote Erin will mirror the requirements of unregistered title. So the charge must be registered on the folio, the charge should contain relevant powers, the property should be transferred by the registered owner to the receiver as attorney for the registered owner, and the assurance should be signed by the receiver as attorney for the registered owner. Mortgagee v receiver transfer. I would point out that in addition, the major difference between the sale of property by receiver and the sale by a bank pursuant to a power of sale is that any charges under which the receiver is appointed and queen burdens are not cancelled unless the appropriate evidence is lodged to support the cancellation, so that separate discharges are to be lodged to address. In the case of Form 24 by a mortgagee, no separate security discharge is needed. Note the Conveyancing Committee's practice note from July 2007 regarding e-discharges. If the mortgage on foot of which the receiver was appointed is cancelled off a land registry folio by e-discharge prior to the lodgement of the transfer by the purchaser solicitor, the application for registration of the transfer will be rejected by TE. When a dealing is rejected in these circumstances, the remedy is an application to the High Court under the 1964 Registration of Title Acts, which is a cumbersome procedure and involves the purchaser in considerable expense. The Conveyancing Committee notes that there is no fail-safe solution to this aspect, and there was some merit in purchase solicitors ensuring that they lodge the transfer dealing in the land registry as quickly as possible following closing. However, there could still be a problem if the e-discharge has been lodged ahead of the transfer dealing, or if a dealing is rejected before the dealing is relodged. Ideally, provision should be made in the contract to provide for the use of a paper discharge in receiver sales, which will be channeled through the purchase solicitor. While all who support e-conveyancing, including the Conveyancing Committee, might see this as a retrograde step, it seems to the committee that a paper form of discharge is safer than an e-discharge from a practical point of view in receiver sales. Turning to liquidations, the next insolvency practitioner we're going to look at is a liquidator. Many of the issues you encounter when acting for a liquidator are similar to those encountered with the receiver. One of the main differences, however, is the liquidator's ability to disclaim owner's leases. But before looking at this, we'll briefly review the role of a liquidator and the different types of liquidations, of which there are three. The closing documents required in each case, which vary depending on the type of liquidation, and liquidator execution requirements. Liquidation is a process whereby companies wound up and dissolved. It marks the beginning of the end of life of the company. Liquidators are appointed to step into the shoes of the directors. The liquidator oversees the winding up of the company and ensures that funds are allocated in the correct manner. The liquidation process is governed by Part 11 of the 2014 Companies Act, the Rules of the Superior Court 1986, and a substantial body of precedent case law. The liquidator's primary duties are to take control of the company, collect its assets and dispose of them, pay off creditors or pay dividend out of any available assets, distribute any surplus among the company members, and investigate the conduct of the directors and bring any applications for restriction of directors unless he or she is relieved of this obligation by the Director of Corporate Enforcement. There are three different types of liquidation, as you see from the slide: members voluntary, creditors voluntary, and court liquidation. One is solvent and two are insolvent. In the case of a solvent liquidation, the members voluntary this is available where the company is solvent. It can be initiated in one of two ways: by the summary approval procedure as set out in the Companies Act, or under the provisions of Section 580 of the Companies Act. In both instances, the directors of the company must sign a declaration of solvency, providing that having made due inquiries, the directors are satisfied that the company will be in a position to pay its debts in full within a period not exceeding 12 months from the commencement of the winding up. Within 1 month of the declaration, the members must resolve to wind up the company and appoint a liquidator by ordinary resolution pursuant to Section 580 of the 2014 Act, or if by the summary approval procedure by special resolution. Then a report of an independent person is also required, which must state that in the independent person's opinion, the declaration of solvency is not unreasonable. In the case of insolvent liquidations, this is a creditor's voluntary and court liquidation. We see that the creditor's voluntary liquidation is initiated by the board of the company. A court-ordered liquidation is generally imposed by or initiated by a disgruntled creditor. The company must cease to carry on its business, except insofar as this may be required for the beneficial winding up of the company. The liquidator represents the company as its sole officer, and accordingly the powers of the directors will cease. As with purchasing from a receiver, when buying from a liquidator, it's important to ensure the following: that the liquidator has been validly appointed, which we will deal with in the case of the closing documents for each type of liquidation. In the case of a power of sale, there's no security document in the liquidation, and we see that the liquidators have a power of sale by virtue of Section 627, subsection 3 of the Companies Act. Appropriate special conditions are to be included in the contract for sale to reflect sale by liquidator, and these conditions would be similar to the type of those used in the case of a receiver, dealing with title, knowledge, etc. Your approach to drafting the contract for sale will be informed by the level of information on title you have and how cooperative the company is being. In this regard, it's very similar to the drafting of a contract for sale for a receiver. Unlike receiverships, however, where the terms of security are very relevant to the receiver's powers, there's no contract to govern a liquidator's powers, which are entirely contained within the 2014 Companies Act. However, various contracts entered into by the insolvent company with third parties, including leases, licenses, finance documents, and extended to wider commercial contracts, will very likely set out the rights of counterparties to those contracts on the entry into liquidation of either party, so that those rights and the implications of them for the property transaction proposed all need to be carefully considered by both parties. In relation to special conditions, again, they have to address the matters that are specified here in the slide in relation to no title covenants, exclusion of personal liability, the problems we identified previously in relation to identifying the property. They will also have to address then the rights, liabilities and conditions of the property. Again, similar considerations in relation to planning will apply as applies in the case of receiver contract, and similarly General Condition 14 in relation to chattels and the inclusion of such in any disposal. Briefly looking at closing documents in the case of a member's voluntary liquidation, there is a helpful conveyancing committee practice note from the 1st of September 1986 setting out the documents which a purchaser should receive when purchasing from a liquidator of a company. You should ensure that the court order winding up the company also contains the appointment of a liquidator, and if not, a copy of the order of such appointment should be obtained. An order for sale of the property will also be necessary. So in the case of the member's voluntary liquidation, you need a copy of the ordinary special resolution of the company as to the winding up as filed in the company's registration office, copy of the liquidator's consent to act, copy of the notice of appointment of the liquidator endorsed with his or her acceptance of appointment as filed in the company's registration office, and a copy of the declaration of insolvency. If the directors are to be joined in the sale, a copy of the authority of the Committee of Inspection sanctioning the continuance of the powers of the directors under Section 2693 of the Companies Act 1963 should also be provided. In the case of a creditor's voluntary liquidation, you'll see from the slide, the documents required are copy of the ordinary resolution of the company resolving to wind up the company, copy of the liquidator's consent to act, copy of the notice of appointment of the liquidator endorsed with his or her acceptance of appointment as filed in the company's registration office. On execution by the liquidator takes over the function of the directors, and according to the execution of a deed of assurance by the company in liquidation should be effected by the affixing of the company's seal, which should be attested by the signature of the liquidator. The liquidator then should also be joined in the deed as with the receiver and execute as liquidator to confirm the sale and give receipt for purchase monies. One point to note is that in all of the liquidation scenarios, the company's corporate status continues until it's dissolved, and its property continues to be held by the company unless the liquidator applies to the court to have it vested in his or herself. I now want to look at a liquidator's ability to disclaim onerous leases. Section 615 of the Companies Act 2014 provides the right to apply to disclaim onerous contracts. The leave of the court is required. So firstly, it's established that onerous property includes leases. Onerous property includes lands of whatsoever kind burdened with onerous covenant. It includes an unprofitable contract, and it includes any property which is unsaleable or not readily saleable by reason of its binding the possessor to the performance of any onerous act or to the payment of money. The right here is for the liquidator to apply to court to disclaim the owner's contract, and then the court decides whether to grant leave to disclaim and on what grounds such leave is granted. The liquidator must apply to court within 12 months of his or her appointment. The disclaimer process can be quite slow, and Section 615, subsection 7 of the 2014 Companies Act gives the landlord an ability to force a decision. The liquidator cannot disclaim where a written application has been made by the landlord, requiring the liquidator to decide on whether or not to apply for disclaimer. The liquidator must give notice of intention to apply for leave to disclaim within 28 days of receiving this written notice. If no notice is given within this period, then the liquidator loses the right to apply to disclaim. If a tenant company in liquidation successfully disclaims the lease, a landlord will only be entitled to claim in the liquidation as an unsecured creditor for the damages suffered as a consequence of the disclaimer. In the case of a lease, the damages will be measured at the quantum of the rent payable to the expiry of the term of the lease, less a measure of the rent which can be expected to be achieved during that period. Other criteria will be taken into account in assessing the claim, including, for example, the date of the next break clause, if there's any break clause, and the prospect of a new tenant, depending on market conditions at the time. I now want to consider the effect of disclaimer on third parties. While a disclaimer discharges the company and the liquidator from further liabilities under a lease, it does not affect the right of third parties. This accords with the common law positions laid down by Judge Keane and Tempany v. Royal Liver, Trustees Limited. In this case, Mr. Justice Keane held that the release of a surety was not necessary for the purposes of releasing the company and the property from liability. Therefore, the liability of the surety was not affected by the ability of the tenant to disclaim the lease. A landlord retains the right to pursue any guarantor of the tenant's obligations pursuant to the lease for losses in the event that there is outstanding rent owing, notwithstanding the disclaimer. In that case, the court also clarified that the principle extends to an original tenant who sublet to the company in liquidation and the guarantor of a company's liabilities under the lease. This provision is hugely significant for landlords as they can bypass the often futile process of claiming the liquidation and seek to recover against one or all such parties. And you should also note that a guarantor could opt also to take over a lease as opposed to paying the damages on foot of the lease should that proviso be available in the lease document. If holding from a liquidator company, a subtenant can rely on the tenancy as against the landlord to enable them to remain in the property. A landlord can re-enter for breach of a disclaimed head lease, and in such case the subtenant can apply to the court for relief against forfeiture. It would need to pay the head rent and apply to have the tenant's interest vested in it. A court can hold that the subtenant is liable from the vesting date and doesn't take on the accrued liabilities. In the case of Total Aaron and disclaimer of a lease, registration of the disclaimer requires the lodgement of the following documents. Form 17, obviously, the original lease, the official copy of the court order giving the liquidator the right to disclaim, and the official copy of the notice of disclaimer by the liquidator. The official copy of the vesting order of the court pursuant to Section 6161 of the Act stating in whom the disclaimed leasehold property is to vest, and then an application in the form of Form 57B of the rules adapted to meet the needs of a particular case by the liquidator or the solicitor for the liquidator to cancel the lease registered as a burden on the affected folio and to close the leasehold folio if it's been opened. In summary, in selling a property as a receiver, acting for a receiver or liquidator, or buying from a receiver or liquidator, the main differences as opposed to a normal conveyancing transaction are the requirement to investigate the validity of the appointment of the receiver or the liquidator and to be satisfied on the documentation that's provided in this regard, investigation of title, a more focused review of the special conditions that are contained in a contract in dealing with a particular sale, the exclusion of the personal liability of the insolvency practitioner, and the detail of the closing documents and the additional closing documents that are required in such a sale, and lastly, the execution of the documents by the receiver and or the liquidator. We're going to turn now to examinership. We're going to look at an examiner and his or her purpose and role. We're going to look at repudiation of leases, and we're going to consider guarantees in the context of examinership. Examinership is a statutory alternative to winding up. Its purpose is to facilitate the survival of the whole or any part of a company as a going concern. It is in effect a rescue procedure for an insolvent company, and it's the process by which an insolvent or imminently insolvent company may apply for court protection from its creditors, during which time, if the protection is granted, it seeks to reorganise its affairs through new investment in the company and a forced write-down of the company's current liabilities. While a scheme of arrangement is being formulated, which, if it's ultimately approved by the court, will be binding during the protection period, during that protection period, no winding up proceedings may be commenced, no receiver may be appointed over any part of the company property, and a receiver may not act if already appointed without the examiner's consent. Effectively, on the examinership procedure allows a period during which the company can reorganise itself. The purpose of the examinership. Section 509 of the Companies Act sets out the basis and requirements for an examinership. For a company to petition the court to be placed in examinership, it must be unable or likely to be unable to pay its debts, and no order or resolution subsists to wind up the company. In such circumstances, the court, on application, may appoint an examiner to examine the state of the company's affairs, but it will only make an order to do so if there is a reasonable prospect of survival of the whole or part of the undertaking as a going concern. If satisfied, the courts may place the company in examinership, and this will be a 70 to 100-day protection period of the court, whilst the company's affairs are investigated by an examiner to see whether the company is capable of being rescued. Section 511 of the Companies Act provides that a petition for the appointment of an examiner must be accompanied by a report of an independent expert, and that report must show a reasonable prospect of survival of the company. In 2022, changes were made to bring the examiner process in Ireland in line with the EU Directive on Preventative Restructuring Frameworks. Impairment of creditors' interests. An examiner scheme will not be binding on creditors whose interests will be impaired by the scheme and who were not given notice of a meeting which they would have been entitled to attend. The regulations also introduced a requirement that the examiner is further required to ensure that all such impaired creditors are invited to attend such a meeting. And for the appointment of an examiner in cases involving cross-border elements, the court must be satisfied that the proposed examiner has sufficient experience and expertise to perform the role. An examiner is an officer of the court, not the company, and therefore has a duty to act in a neutral and bona fide manner. Once the test for appointment is satisfied and court protection is issued, the role of the examiner is to examine the company's finances, to establish what parts of the company are capable of survival and rescue, to negotiate with investors, creditors and shareholders in order to prepare proposals for a scheme of arrangement, and to prepare a scheme of arrangement to put before the court. Where the court confirms the scheme of arrangement and the proposals of the examiner, the proposals will be binding on every class of creditor and member. Pending formulation of the examiner's report, the court can, on application, order the disposal of property subject to floating or fixed security, as if the property were not subject to such security. The most common property law issue encountered in an examinership process is the repudiation of leases, which is governed by Section 537 of the 2014 Companies Act, which we'll now look at. Section 537 provides that where proposals for compromise or scheme of arrangement are to be formulated in relation to a company, the company may, subject to the approval of the court, affirm or repudiate any contract under which some element of performance other than payment remains to be rendered both by the company and other contracting party or parties. The case law concerning repudiation initially focused on whether a lease qualified as a relevant contract capable of repudiation. The two main cases dealing with this point were the cases of O'Brien's Irish Sandwich Bar and Linen Supply of Ireland Limited. In both cases, the company petitioning for leave to repudiate onerous leases were operating their businesses out of a number of leasehold premises. In the O'Brien's case, the High Court held that the lease did not come within the requirements of Section 537 subsection 1. However, this position was subsequently overturned by the Supreme Court in the Linen Supply of Ireland Limited case, which held that leases were eligible contracts. By their nature, leases involved the performance of obligations by both parties other than the payment of rent, and it was found that leases could be repudiated provided the scheme of arrangement was ultimately confirmed. Although leases are capable of repudiation, the court will consider a number of factors in any application to determine whether to grant leave to repudiate. Whether the court will grant leave to repudiate will depend on the individual circumstances and the impact it would have on the scheme of arrangement. And the factors that may be taken into account by the court in deciding whether or not to grant such relief will be whether the lease is surplus to the company's requirements or burdensome, whether an investor is not willing to put money into the company if the lease has remained, or if the examiner was of the view that he or she could not put together a scheme of arrangement unless the lease were repudiated. Turning to Section 537 subsection 2 of the Companies Act, if the court permits the repudiation of a lease and the scheme of arrangement is confirmed, any party who suffers loss claims then as an unsecured party. By way of note, I want to mention that Section 5284 of the 2014 Act allows an examiner to apply to the court for the same powers as are afforded to a liquidator disclaiming owner's property in accordance with Section 615 of the 2014 Act, which we did discuss earlier. Three final points on examinership, and if you're only to remember one of these points, I think the first one is the most important. As with disclaimers, third-party guarantees remain enforceable. Section 548 of the 2014 Act provides that third-party guarantees are enforceable, notwithstanding that a scheme of arrangement compromises the creditor's recourse to the company, which is the primary debtor. If a creditor wants to enforce the obligation of a guarantor, they must serve notice on the guarantor within a particular time frame set out in Section 549 of the 2014 Act, which notice should contain a written offer to transfer to the guarantor any rights the creditor has, so far as they relate to the debt, to vote in respect of proposals for compromise or scheme of arrangement in relation to the company. Where a creditor opts to enforce a guarantee, any rights he has in the examinership arising from this debt can pass to the guarantor. And Section 549 provides for specific time frames, which are if the 14 days or more notice is given of such a meeting, at least 14 days before the day in which the meeting concerned is held under Section 540 to consider the proposals. Or if less than 14 days notice is given of such a meeting, not more than 48 hours after he or she has received notice of such a meeting. The notice to be served should contain a written offer to transfer to the guarantor any rights the creditor has so far as they relate to the debt, to vote in respect of proposals for a compromise or scheme of arrangement in relation to the company. Where a creditor fails to make an offer to a guarantor, they cannot enforce by legal proceedings the obligation of the guarantor in respect of the liability unless a compromise or scheme of arrangement is not entered into or does not take effect and the creditor has obtained the leave of the court to enforce the guarantor obligation. Section 544 of the 2014 Act prohibits the compromise or scheme of arrangement from providing for the extinguishment or reduction in the amount of rent or other payments due in respect of a lease of land after the scheme is approved, which means that a scheme of arrangement cannot provide for the extinguishment or reduction of rent payable under a lease unless the lessor consents. And finally, Section 5326, subsection 6 of the 2014 Act places the examiner's liability on the same footing as a receiver, in that an examiner shall be personally liable on any contract unless the contract provides that he or she is not to be personally liable on such contract. Turning now to SCARP, the Small Companies Administrative Rescue Process. This process was introduced by the Companies Act 2021, and the purpose of SCARP is to make the benefits of an examinership type process more accessible to smaller micro companies, which represent 98% of Irish companies. It therefore adopts the key principles of examinership to create a new process available to such companies to restructure their debts. Given the lack of court oversight, the SCARP process safeguards against irresponsible and dishonest director behaviour by providing for A risk of criminal offence for a director's failure to provide any relevant information or providing false or misleading information during the process, and B, an obligation on the process advisor to report certain director offences to the DPP and the ODCE. A small company is one with a turnover not exceeding €12 million and a balance sheet not exceeding €6 million and an average number of employees not exceeding 10. A micro company has a turnover not exceeding €700,000, a balance sheet not exceeding €350,000 and an average number of employees not exceeding 10. So a company must be deemed as a smaller micro company as defined. It must be unable to or unlikely or likely to be unable to pay its debts, have not passed a resolution to wind up the company, have no order against it to wind up the company, and have not availed of SCARP in the preceding 5 calendar years. So in the case of SCARP, we deal with a process advisor. So the directors, having conducted an inquiry into the affairs of the company, submits a sworn statement of affairs to a process advisor who will be an individual qualified to act as a liquidator. The process advisor confirms whether, based on the report, there is a reasonable prospect of survival and prepares a report, which may include draft proposals. It will set out conditions to be fulfilled, pre-petition liabilities, funding, fee arrangements. Within 7 days, the board of the company, having considered the process advisor's report, must formally pass a resolution to appoint a process advisor, issue a notice of suspension of payments for the process period, and commence or continue discussions with creditors, and ultimately issue a rescue plan, and deliver a resolution to court, creditors, and the company's registration office. Looking at the powers and role of a process advisor, the process advisor has similar limited powers as an examiner. The process advisor will certify liabilities which will take priority over floating charge assets in a liquidation, and apply to court to repudiate or affirm a contract, and deal with charged property where it's likely to facilitate survival as a going concern. The process advisor must deliver proposals for a rescue plan within 42 days, and those report or proposals provisions will directly mirror the examinership provisions, allowing for a write-down of debts, excluding taxes and other state creditors. There's provision to convene a member of creditors' meetings to vote on the proposals. They must be approved by a majority in value of a particular class, and the rescue plan shall become binding on all creditors where it's accepted by at least one class of creditors. We'll conclude this lecture segment with a few points on NAMA, the National Asset Management Agency. The agency is set up under the 2009 Act, NAMA Act, the National Asset Management Agency Act, which gave NAMA broad and far-reaching powers, including in certain instances curative powers. I want to briefly look at statutory receivers and points that arise in a sale of property by NAMA. Section 12 of the NAMA Act sets out the agency's powers, including all powers necessary or expedient. And we will look at vesting orders, statutory receivers, and contracts where the vendor is a statutory receiver or NAMA holds the charge. A receiver appointed by NAMA is referred to as a statutory receiver, and the power to appoint comes from Section 147 of the NAMA Act, which provides NAMA with the ability to appoint a receiver over what's called an acquired bank asset. The appointment under Section 147 of the Act is not subject to any restrictions on the exercise of the powers of a receiver under the Conveyancing Act 1881 or the 2009 Act, which restrictions we would have looked at earlier on in the lecture. All transfers of eligible loans from the participating institutions to NAMA were made to the National Asset Loan Management Limited and not to NAMA. NALM is the abbreviated term, and accordingly all discharges and releases would be executed by NALM. The receiver is the attorney of the registered owner of the property affected by the charge, and therefore transfer by the statutory receiver does not overreach the interests of owners of burdens ranking out the charge, and in the absence of appropriate discharges, these remain on the title. You will recall that we have seen in relation to our contractual receiver that this difficulty was got over by a sale by a mortgagee not in possession. If it's certified on behalf of NAMA or NALM that the receiver is a statutory receiver, then no further evidence of appointment is required. A statutory receiver has the powers, rights and obligations that a receiver has under the Companies Act, and the powers, rights and obligations specified in Schedule 1 of the NAMA Act in Appendix 3. He or she shall be taken to be the agent of the chargeor for all purposes, and shall be taken to have been irrevocably appointed as attorney of the chargeor, with full powers of substitution and delegation, and to have the authority in the chargeor's names. The Law Society Conveyancing Committee helpfully on September 2013, the 6th of September, published a useful practice note on sales of property where NAMA is the charge holder. And you should take a look at this practice note. Where NAMA is a releasing security, you should include a recital dealing with the transfer of ownership of the relevant security to NAMA pursuant to the NAMA Act. NAMA must also certify that pursuant to Section 108 of the NAMA Act, the relevant security is an acquired bank asset. Once it's certified by NALM, the practitioners do not need to investigate NALM's rights to the relevant security or that it's the correct entity to release the security. Schedule 3, Part 8 deals with the amendment of the Planning and Development Act 2000, and this entitles NAMA to require a planning authority to extend the planning permission by an additional period of 5 years, or in exceptional circumstances 7 years, to enable a development to be completed. This was an additional power granted to NAMA in order to facilitate it in disposing of relevant assets. The planning authority must be satisfied in such circumstances that considerations of commercial, economic or technical nature beyond the control of the original applicant mitigated against the commencement of the original development or the carrying out of substantial works in considering the extension of such a planning permission. And just also point out Section 142 of the NAMA Act provides that any instrument under the seal of NAMA which relates to land in which NAMA has an interest and seeks to convey that interest is effective as a deed under seal. Looking at the sales process, a vendor of a NAMA charged property will require the prior approval of NAMA before proceeding with any proposed sale. The approval will issue on the basis that the proceeds in a specified amount are received by NAMA. The approval may also set out other commercial conditions which must be adhered to, and the Conveyancing Committee recommended that a practitioner acting for a vendor should obtain a copy of the conditions imposed by NAMA or a participating institution in relation to the sale from the vendor. Two other points I want to highlight. The Act provides NAMA with the power to overreach, not the receiver. Section 142 of the NAMA Act provides that any instrument under the seal of NAMA which relates to land in which NAMA has an interest and seeks to convey that interest is effective as a deed under seal. Section 143 of the NAMA Act provides that a conveyance by NAMA to a purchaser of a legal estate or legal interest in land overreaches any equitable interest in the land, so that the equitable interests cease to affect the state interest, whether or not the purchaser has notice of the equitable interest. Section 172 of the provides that NAMA will require confirmation that the transaction is arm's length with no connected parties, and a declaration will be required on completion to this effect from the purchaser. Looking at contracts for sale, as with all receivership sales, special conditions should be provided to reflect the nature of the transaction. A special condition should be included to deal with Section 172 so that the required information and verification by way of declaration is provided by the debtor. The normal special conditions excluding liability should be included, and you should consider the general conditions of sale to clarify what conditions need to be varied by way of special condition. You will also need to have confirmation that the commercial conditions imposed on the subject to which the NAMA consent is provided have been complied with. In advance of completion, the vendor or solicitor should obtain a copy of the confirmation given to the vendor by NAMA or the participating institution that the commercial conditions other than the payment of the net sale proceeds have been complied with. Final 2 points on this. In the case of NAMA and NALM, all transfers of eligible loans from the participating institutions to NAMA were made to National Asset Loan Management Limited and not to NAMA, and accordingly all discharges and releases, etc. should be issued by NALM. In relation to releases furnished by NAMA, the Conveyancing Committee's practice note that we mentioned earlier on sets out advices in relation to NAMA's practice in the matter. We have already mentioned that NAMA, establishing that NAMA is the owner of the charge, is dealt with by way of the Section 108 certificate in the deed. And then finally, in relation to deeds of release, the form of the deed should be agreed with NAMA prior to completion. NAMA's practice is not to issue executed releases or discharges to be held in trust pending completion. Instead, it will issue a letter addressed to the vendor or solicitor confirming that in receipt of the net proceeds of sale, it will furnish a release in the agreed format executed by NALM. On the basis that NAMA is a state body, the conveyancing committee has recommended that practitioners accept this letter for completion purposes. And NAMA has at this point developed a suite of template release and discharge documents to be used in all transactions. One final point to note is that now in 2025, it is anticipated that NAMA will ultimately be wound up before the end of this year. Thank you for your attention.